Hey everybody, this is Mr. Moppin coming at you with another APUS government video. This is our fifth and final video focusing in on the topic of constitutional interpretations of federalism. This is topic 1.8, and throughout this topic we've been taking a look at that relationship known as federalism between the federal government and the state governments. And specifically in our last video we talked about how the Commerce Clause was broadly interpreted through most of the 20th century. And just as a quick review, as you take a look here, it says that in Article 1, Section 8, it says that Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The most important part of that is in the middle where it says among the several states. That's interstate commerce, trade, business, across state lines. And we mentioned previously that the federal government had been able to use a very broad interpretation of the Commerce Clause to be able to regulate all sorts of things in society, up to and including the Civil Rights Act of 1964. So if you looked at the history of interpreting federal power via the Commerce Clause, there was a very clear trend for many, many years that the federal government's power just seemed to keep expanding and expanding and expanding. And remember, when we're talking about power under the Constitution between the feds and the state governments, it really is a zero-sum game at the end of the day. So if the federal government is growing in power, then that means conversely that state power is shrinking. Now, once again, there's a sense that, hey, this is just going to continue and continue and continue. And maybe the states really wouldn't have much power at all in the future. But as we get towards the end of the 20th century, the Supreme Court had become more conservative in nature. And with that more conservative membership ideologically, the court is going to start to create some boundaries for federal power via the Commerce Clause. In some respects, the court is kind of saying, okay, that's enough, federal government. You've gone as far as you kind of can in some of these areas. And that's going to be the focus for today, where you're going to be seeing two court cases that are going to be examples of the court putting that limited, or putting some sort of limitations on the federal government in terms of its authority via the Commerce Clause. And one of those cases is a case that you do have to know for the AP test. And that case is U.S. v. Lopez. So remember, as you can see here, at the bottom here of these notes, that there are 5 things that you got to know for each of these required U.S. Supreme Court cases for the big AP test. Remember, it's the background of the case, constitutional issue or issues, who won the case, why, and the long-term impacts of the ruling. So those are the 5 things you always got to know. And with regards to U.S. v. Lopez, let's start with the background. Now, in the case of Lopez, this is focusing in on a young man that was in high school in the state of Texas and brought a handgun to school. Now, this young man, Lopez, was charged under a federal law that was known as the Federal, Gun-Free Zone Act, that banned any possession of a firearm on or near school campuses. Now, when Lopez was found guilty of that federal law, we're going to see a challenge in the court. And as you can imagine, the challenge being is that, is this federal law constitutional via the Commerce Clause? Because that was the argument that the federal government used to justify the constitutionality of this law. Basically, the federal government argued that this law that banned possession of guns in school zones was tied to the Commerce Clause because of the idea that, well, if you don't protect people from gun violence, then it's going to have an impact on the economy. For example, if more people become victims of gun violence, then the cost of insurance is going to increase. For example, think life insurance policy rates. Those premiums would go up if more people are, victims of gun violence. There's also a concern that if schools do not properly protect students from gun violence, then that is going to impact the quality of education, that therefore is going to impact the quality of the commercial environment of the future. So all those things are some of the arguments that the federal government was going to be throwing at to support this. But at the end of the day, though, the court is going to reject those arguments made by the federal government and stipulate that no, the federal government's law, this Gun-Free School Zones Act, is unconstitutional, that The Commerce Clause does not stretch that far. I mean, it has stretched very far in the past, but it did not stretch that far moving forward. So that's going to be an important limitation that the court puts on that. So, that moving forward, the Commerce Clause can only go so far, and conservatives have created some boundaries for that. Now, another case that parallels that, though you do not have to know it by name, is the case of U.S. v. Morrison. In the case of U.S. v. Morrison, this is focusing on a situation where a young woman that attended Virginia Tech University was a victim of sexual assault. Now, following this brutal act, this young woman would take advantage of a federal law known as the Violence Against Women Act. Now, one of the provisions of the Violence Against Women Act allowed victims of sexual assault in these kinds of educational environments to be able to sue for damages, sue their attackers for financial damages, and perhaps sue the educational institution that perhaps maybe did not provide enough security or protection, etc. Etc. So, with that being said, when this individual files the lawsuit and goes to win damages, this is going to be challenged in federal court. This is going to be taken up by the Supreme Court, and the Supreme Court is going to reject this provision of the Violence Against Women Act, basically saying that just like in the case of Lopez, the federal government's argument that the ability to be able to sue for damages via federal Commerce Act authority doesn't really fit in with interstate commerce. The federal government basically was arguing once again that if people do not feel safe going to school or residing on a school campus, etc., they're not going to be able to get a quality education. And that's going to have a negative impact on the nation's commerce in general. And the court's going to reject that, basically saying that there's not clearly enough tie to interstate commerce to justify the federal government's law in this case. So both Lopez and Morrison are going to be argued by the federal government in the same way, for the same reasons, and the court's going to find both of these laws unconstitutional for the same basic reasons. The idea being that the Commerce Clause does not really apply at the end of the day, that you can't stretch it so broadly. Now, what's important to understand when we look at these rulings, in the case of U.S. v. Lopez, don't take the Supreme Court's ruling that the Gun-Free School Zones Act is unconstitutional to mean. Don't take that to mean that the Supreme Court is pro-gun violence. It's not like the Supreme Court saying, "Oh yeah, go ahead, kids. Bring guns to school. You got a right to do it. Yada yada yada." No, they're not saying that. And just like in the case of U.S. v. Morrison, when they do find parts of the Violence Against Women Act unconstitutional, the Supreme Court is not advocating violence against women. That's not what they're saying. So what is the court saying? Well, what the court is basically saying here, and these are great examples of federalism, this relationship between the federal government and the states. What the court is saying in both of these rulings is that there are legitimate reasons to have these kinds of laws. The court does support school zones that are gun-free. The court does support the protection of women from violence and does support a woman's ability to seek damages for being victims of violence. But what the court is saying is that those laws, those regulations cannot be put in place by the federal government. It can only be put in place. And in fact, the court will say in these rulings, they advocate that they should be created, but they can only be created at the state level. That's it. So in the case of U.S. v. Lopez, only the state of Texas could create this gun-free zone law. Or in the case of U.S. v. Morrison, it would require the Commonwealth of Virginia to create the legislation to provide, the ability for a woman that's a victim of violence to sue their attacker. It has to be done at the state level because the Constitution doesn't give the federal government that kind of authority under the Commerce Clause. So basically, the idea being is, and once again, when we talk about government power as a zero-sum game, anytime that you put boundaries on federal government authority, if you limit that, then what that's going to do then conversely is bolster power for the states. So when these rulings by the court say, no, 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 federal government, you've gone too far, these laws are unconstitutional, you're pushing back against federal authority and therefore broadening more state power as a result. So be aware that when we do talk about this relationship between the federal government and the states via federalism, and once again, that relationship is going to ultimately be interpreted as to what it really means by the Supreme Court. Understand that that relationship is dynamic. It changes over time. So please keep that in mind. All right, so we're going to leave it there on topic 1.8. We'll see you next time. Bye-bye.